Can you pass me my shirt, please? Thank you. No, delete Telegram.
Huh?
No, you can have it. Ah,
Huh?
you could have closed the door.
What?
You could should have closed the door. See that? Definitely not. Clearly.
Can you hear me?
Yes, sir.
Okay. My apologies. I'm on the road and route to work.
Okay.
Hey, hello?
Hello?
Yes.
Yeah, we haven't started yet.
Okay.
Yeah. There's not your mic. Please mute your microphone until you're called.
Alphonse Hogan.
Please mute your microphone until your docket is
Hold on.
called.
Hold on.
Thank you.
Could you say that again, please?
Please mute your microphone until your docket is called. Okay, Mr. Chairman.
Okay, we can start up with the preamble. In compliance with notification requirements of Ohio's open meeting law in section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting has the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Call-in users can unmute by using *6. All meeting activity is being recorded by way of the WebEx platform. These proceedings are also being live streamed by way of YouTube. All requests to speak on a particular matter by way of our website and email have been considered. We have also received emails from those who have provided written comment on a particular matter. Mr. Jacobson.
Mr. Chairman, this is Dan Jacobson from the Law Department. Preliminary matters, the live stream. Can we verify that the live stream is on and functioning?
Yes, it is.
And Mr. Chairman, as the Law Department has done since these meetings have gone public and or virtual, law states its objection to the use of the chat function. Thank you.
Okay, thank you. Ms. Davis.
Mr. Bradley?
Here.
Mr. Maschke?
Here.
Mr. Dink?
Here.
Mr. Gallagher?
Here.
We have a quorum.
Okay, well, first docket is docket A9923, 3405 East 114th Street, and that has been postponed. So we'll move on to docket A3123, 10308 Adams Avenue.
Application and fees are in order. Notice of violation is interior and exterior maintenance, issued on May 22nd of 2023. Appeal was received June 12th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson, Law. Will the appellant or his or her attorney or representative please state your name and relationship to the property?
Good morning. This is Attorney Jessica Barwell. My firm represents appellate 10308 Adams Avenue.
Ms. Barwell, you solemnly swear to tell the truth, the whole truth, so help you God?
Yes, I do.
Is there anyone else speaking, or are you going to be doing all the talking?
I should be doing all the talking unless my client needs to be speaking.
Okay, if they do, then we'll need to swear them in. Okay, go ahead and proceed.
Yeah, so our client was issued this violation in May of 2023, and then we requested the extension and filed for this appeal. There were 12 items listed on the violation. Items 1 through 5 have all been completed, or partially will be finished this week. Items 9 through 11 have been completed. And then the exterior work, we are requesting an extension through the end of March. There was a very difficult time regaining access to the property due to the tenant at the time being very abusive with the contractors, not letting them in. And finally, we got through the eviction process. So the tenant abandoned the property in October, and we were finally able to get a contractor in. And then there was a break-in that occurred in October, and a 2-year-old furnace was stolen. There's a police report on that. And then in mid-November, another attempted stealing of that furnace. A second police report was we have. And the contractor has been working very diligently. And due to the winter weather, the exterior work is going to take some time to complete. And that's why we request the March 30th deadline.
Okay. Mr. Vanover.
So, Mr. Chairman, to the appellate, is the property currently vacant?
Yes,
And this is a 1-family or is it a 2-family?
this is one. It's just the lower unit of the property.
So it's a 2-family dwelling,
Yes.
and both units are vacant?
I believe that the upper unit is not vacant. I'd have to swear in Rodney.
Okay, who's going to be speaking?
Rodney Doss.
Okay, solemnly swear to tell the truth, the whole truth, so help you God.
Yes, sir, I do.
Okay, go ahead.
Yeah, the upper unit is occupied presently. The lower unit is vacant and the contractors are working.
So, Mr. Chairman, these, Mr. Chairman, to the appellate, these are owned by, let me verify, because our records show that these are owned by an LLC. Is that accurate?
That is correct.
CLE 10306 Adams LLC.
That is correct.
Yeah, Mr. Chairman, so these notices were issued in May of the previous year. And while I understand that tenants can be difficult, the exterior work could have proceeded without entry, even with the difficult tenant. And now here we are, by the time, this is a full year to renovate a property that should have been completed. This work should be done before the citizens, the city have to pay an inspector to go out and look at this. Look at the, site the place, basically, is what I'm saying, is that this should have been done before we got there. So, I mean, at this point, we're at December, but I ask that any time given would be very limited. I'm looking through our records. There's also an HVAC violation notice on this back from May, but you said that there was a 2-year-old furnace was stolen from the property? Mr. Chairman, to the appellate? Was that the testimony that I heard?
That is correct. With a second attempt at stealing the other furnace that's located in that property for the upper unit. 2 separate police reports. And just a point of interest here, This has not been ongoing for a year. It's been ongoing for 5 months, this month.
Yeah, I see the violation notice was May 22nd, 2023.
And Mr. Chairman, your request is until March,
The end of March. I think it's
end
what-
of March. So I misspoke. It would be 11 months, not a full year. If you get to if we have the end of March, and this began at the beginning of May of this year. So, Mr. Chairman, being that at least a portion of the, it is occupied, we would ask that any extension of time be very limited. I do not have any records in our system that there was ever an application or a permit pulled for furnace replacement within the last 5 years. So, yeah, I don't know where the 2-year-old furnace came from, because we have no record of that work being done. So we ask that you, it's gonna continue to be a problem when you have a vacant property, but we ask that any granting of time be limited. With the
Right,
understanding that
I don't-
the vacant unit will not be occupied until the violation notices are closed.
Okay, so that's a reason to get it done sooner. Do we have a good picture of the outside? I see one in the lower section that shows the outside of the property, but I don't know how extensive that is on the outside to what has to be done, or whether it can be done in the winter. If it's not a paint job, if it is a siding job, what is it made of? Does anyone know?
It's wood siding, sir.
Okay, so you're talking paint.
Yes, sir. Well, it's actually more than paint. We are making application, and I've noted all of this information in an email to Inspector Blazvik, that we're making application to get either a grant or a low-income loan, low-interest loan to put new windows in this property and siding with new insulation on the exterior, which cannot be done during the winter months. We've got a lot of work done on the interior of the property, and that was our focus with the weather coming bad, was to get the interior done so that we can make sure that a family that wanted to move in would have housing through the winter months in a nice apartment. We had to rebuild the floor in the bathroom area of the lower unit, completely gutted it, put new flooring in, new sheetrock on the walls, new tub, new vanities, new medicine cabinets, and I sent pictures of that work in progress, and almost completed, probably be completed tomorrow. Sent pictures of that work in progress to Inspector Blazvik, and our attorney has those pictures also, so they can be shared with you to show that we are making the effort. Not only that, but we've got 12 code violations listed in our work program that we've put together for that unit. It has actually got 33 work items that we're doing to it. So we're not just going in and addressing code violations. We are actually remodeling that complete lower unit and upgrading it, putting some new flooring in it. This is not just slapping a coat of paint on it to meet some code violations. We are making an effort to improve that property from top to bottom. So when we get finished with the property, it will be probably one of the nicer units or properties in that neighborhood.
So I think the proviso here is going to be that you're not going to be able to rent that lower section out until all of the violations have been taken care of. So I can give you till April 5th in order to complete all of that work, which will give you through there. but it would seem to me that it would be to your benefit if you would get all this stuff done sooner. You can end up running out that bottom.
Yes.
So I can give you that much time, but you cannot rent it out until it's all taken care of.
Okay, well, we were hoping, and I appreciate that, and I thank you for that. We were hoping that if we addressed all of the code violations on the interior of the house, that would make it a safe dwelling, and that we could offer it up.
Well, I think that if we make it so that you got to get it all done, I think there's a possibility, especially with the way Cleveland's weather is, that you could get a lot of work in possibly even during the winter months. There's a lot of things that can be done. Even some of the windows sometimes can be taken care of. But anyways, is the board agreeable to that? So we would be looking at an April 5th, can't rent it out until he gets all the violations taken care of. Mr.
moved.
Paskey?
So
Okay,
moved.
all right, you got a motion, second?
Second.
Okay, second. Go ahead and call the roll.
What's the year?
Oh, the year,
Yes.
it's 2024,
Thank you.
April 5th, 2024.
Mr. Maskey,
Yes.
Mr. Bradley? Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Okay, your notice will be sent out within 2 weeks. Thank you.
Thank you, sir.
Thank you, everyone.
Madam Chair, do we get to prioritize City Hall? I just didn't know if anybody knew I was here or not.
We did not, and we sure can. Let's see, what's your, your docket number?
Yeah, I've got 5 of them. 22923.
That's your first one?
Yeah, for the housing
Okay.
docket, the rest are lead.
Okay. Okay, so we'll jump to housing docket 22923 to get the councilman in here.
Thank you.
2407 through -2409 Colburn Avenue.
Application and fees are in order. Notice of violation is fire. Issued on August 15th of 2023. Appeal was received September 13th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson, Law. Will the appellant or his or her attorney or representative please state your name and relationship to the property?
Carmela, do you see anyone on there? Might be muted.
I do not see Quentin Straub or the applicant B2B Realty in the participant panel.
Okay, well then we're
We're gonna- We're
Go
gonna, let's get back to them, because I know they have been called in the office a lot the last couple of days. It could be, some type of technical difficulties. Waverly, if you can give them a call, B2B Realty, and see what their status is.
Okay, we can open up the next docket for Councilman Harsh. While we're taking care of that.
Ms. Davis, can you provide me the violation number for that address?
The violation number for docket A 229 would be V as in Victor, 230-19318.
Thank you.
So we want to jump to,
The next docket is 15623. Is that where we're heading to next?
well, there's 143, but it has been withdrawn, 23.
That is correct.
Okay. All right, so we let the councilman know that. And so we're gonna move to 15623.
Is
5-1.
Mr. Ben Murray here? This was a reopened docket. Yeah, I do see him in the participating panel.
Okay, good. 5115 Woburn Avenue.
And then there are two others with the same owner.
Oh, same owner form,
Yes.
okay, all right, okay. We'll, yeah, we'll probably have to open them one at a time, I believe.
Sure.
Okay, you go ahead, Carmelo.
This is, notice of violation is lead deficiency inspections report issued on July 7th of 2023. We received the appeal on July 31st of 2023. We originally heard this docket on November 8th of 2023. Due to technical difficulties with the board, we had to reschedule them to be heard again today on December 6th of 2023 to give this appellant the opportunity to be heard. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson Law. I do believe we have Jenna. She's here from the lead team.
Yes, I'm present.
Jenna, if you can state your first and last name.
Jenna Fryermuth.
Friarly, is that correct?
Fryermuth.
Mute, right? Oh, Friar Mute. Okay, I got you. Okay.
Will the owner and his or her attorney or representative please state your name for the record?
Yes, hello, my name is Ben Murphy. I'm the sole member of Murphy Properties LLC.
Okay, everybody,
Yes.
Victor Santillo, from the lead, City of Cleveland, lead unit is also here.
I'm sorry,
Okay.
Victor, I didn't see you in the participating panel. Let me put my glasses on.
oh, good.
And I'm
Victor,
here
Okay.
as well.
state your
All right.
first and last name as well.
Victor Santillo, Department of Building and Housing.
Thank you.
Okay, all those gonna be giving testimony. I believe I see, Mr. Murphy, Ms. Fryermuth, Mr. Centella, and, the rest of ours, Mr. Vanover, and what are gonna be giving testimony. Solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Yeah.
I do.
Okay, I guess we're gonna begin with Mr. Murphy.
Yes,
Okay, go
so
ahead.
In regards to these properties, this was a portion of the properties that I had inspected. And in any and all of the properties of mine that were inspected, the only issues that were found were around the exterior. They weren't large areas by any means. It wasn't anything huge, but I've had my painter working on those things, and he's always been very reliable. Through this process, I kept reaching out to him as I would, check up, and the date would pass in which he was supposed to have been done on, X, Y, and Z. So I kept on him, And I did bring in some others for some work, and my painter kept telling me he would get there, he was going to get there, you know. I didn't have to call anyone else. So the date passed. The exterior work was not completed on all. It was completed on 2 of the 3 in question. I did not send the inspector back because I just wanted to send him when they were all done at the same time, so all the paperwork could come in at the same time. This is the reason why I had to request an extension, was really just because I think it was one property at that point that wasn't 100% completed. So I went ahead and requested the extension. The work was all done actually right around that date in which this hearing was scheduled. I just had not received the email on that, so that's why that hearing didn't take place. But everything is completed. It was completed within the extension time, and it's ready for reinspection. But at this point, my inspector, I guess, was told to wait until this hearing is done in order for him to turn in the paperwork. So that's where we're at currently. Everything should be 100% completed and acceptable. The last thing I wanted to note is that one property, 3913 Bucyrus Avenue. I'm not sure what happened in the system with this one. I have.
Mr. Chairman.
Discussion.
Right. We haven't opened up them other 2.
I'm sorry.
So just hold off on that one, and we'll get to it. That'll be the next one we'll bring up, and you can discuss that one.
Okay. So what I said was a blanket statement for the whole 3, so I apologize.
Yeah, that's all right. Okay, so that's it then. Mr. Vanover.
So, Mr. Chairman, I'd like to clarify a couple of things here. This is, I guess at this point, I am unclear. This is an objection to the process and to the deficiency letter provided in Mr.
Murphy.
Mr. Murphy's appeal. He requested that his original lead inspection be accepted and as part of this appeal hearing. Just to be clear, that under the lead safe ordinance, there's a requirement that the property be submitted as lead safe. Every rental property in the city of Cleveland is required to have a lead safe certificate that requires an inspection to be conducted and then a clearance report to be submitted. In this case, a report was submitted for the interior of the property, and there were deficiencies in the report on the exterior. The process and ordinance and policy requires that report is submitted within 90 days of the inspection, understanding that the conditions of lead in this city, in our rental property, they are changing, and they change from property to property, really day to day. So while the report was submitted for the interior, there was deficiencies on the exterior. The city of Cleveland at that time, we had a policy to grant a winter deferment for exterior work that is of time certain to get the report submitted, showing that the exterior work also met the clearance requirements. On this property, the time came and went and lapsed for the winter deferment, and the report was not submitted. As Mr. Murphy said, his decision to submit them all together was his decision. The requirement is that the report is in during the deferment time, and failing to do so requires the property to be re-inspected. The position of the City of Cleveland Department of Building and Housing is failing to meet that time. He needs to reconduct the the interior inspection as well as the exterior inspection. As of today, we do not have a clearance report for this property. And so we ask that you uphold the notice of deficiency as properly issued and require, and there's no time to be granted in that this is a deficient property. This is a rental property that has not submitted their lead clearance.
If I can speak to that, please.
Sure.
There's a few things I wanted to address. He did note that the interiors, so I did have all of my properties inspected. The interiors did all pass, and were said to be, lead free. So I definitely tried many different phone calls, emails, things of that nature, and there have been, I've received some help through, asking questions, but what was just laid out was not made 100% clear to me in the way that it was just stated, as far as the process. My inspector did not have all of the information that I was looking for himself either. There were questions he could not answer. So a lot of through this process, and he was unfamiliar with how to resubmit paperwork after the, and again, I did ask him now, prior to this hearing, I did ask him to go back to those properties and resubmit paperwork so that it would be in by this hearing. And he said that the information that he was given from whoever he had spoken with, I think it was Victor, and Victor, you could correct me if this is wrong, but he told me, my inspector told me that he was told to wait until this hearing is over before he would go back out to the properties, in which, as I've stated, they are complete, and they were complete prior to today, prior to November. There was one item that he told me to go back for on one property that he found that I was unaware of right around that November date. So again, that's been taken care of at this point and prior to today.
So
Sorry, I guess I'm just asking for some leniency, because I really have been doing the best that I can do to operate on this new program that is I guess the information is just hard to get as to exactly how to satisfy all requirements. And I was doing my best to satisfy the requirements that I knew of, and I was trying to ask questions to make sure I was clear, and unfortunately this is where we've ended up.
Mr. Chairman?
Yes.
Mr. Chairman, to Mr. Murphy, you stated that the properties were inspected and were found to be lead free.
The interiors, yes, passed. I have documentation back, on all of my properties, and these ones included. I do have those files that show all the signatures and the lead, the results from the lab and those things.
So there's no presence of lead through the chair. There's no presence of lead anywhere in the interior of the property. There's no lead paint. There's no lead paint under new paint. There's no wood windows. There's no lead laden surfaces on the interior of the property. That's what lead free means.
Yes, that's what the reports show. I've replaced windows in these properties prior to inspection. I don't have any wood windows, I don't think, in any of my properties.
So, Mr. Chairman, just to speak to a few statements, the requirement is that if you own rental property in the city of Cleveland, it be either lead safe or determined lead free. In order to be lead free, there has to be no presence of lead, and that has to be inspected, throughout the interior and the exterior. That is the requirement. The requirement is that if you are a property owner that rents property, that you provide us with a lead safe certificate. The state of Ohio is clear on the inspection requirements for a lead clearance. This is a matter, it's not a matter of our rules and our requirements being ambiguous. We require a lead clearance and to get a lead safe certificate. we had offered a deferment program for winter weather, that's leniency. So the ask for leniency and the ask for understanding, that has already been accomplished. We have already granted the applicant we've already granted the applicant leniency when we granted them a winter deferment. So I object to the classification, categorization that we have, that there's no leniency or that there's ambiguous. The rule is lead safe clearance, and then you receive a lead safe certificate. And the request for leniency was granted as part of our winter deferment program. So we are here today because the property was not found to be entirely lead-free at the time of the inspections. The property was not found to, we did not receive the clearance report to offer the lead-safe certificate. So, and now the requirement is that the property be re-inspected and that we receive the lead clearance within 90 days of the inspection, because that's what our requirements are because of the changing conditions, and that we can offer them at that point a lead safe certificate. So
Mr. Murphy, is it lead safe or lead free?
It was said to be, I can pull up the document now to double check, but I believe it was lead safe was the language.
Okay. If it's lead safe, then I think you're going to have it re-inspected. Okay. If it was lead free, then it's lead free. We wouldn't have a problem here. No matter who's expecting it, it wouldn't make a difference. So I believe that in order to meet what Mr. Vanna was saying is that it's going to have to be re-inspected because we didn't meet the timing. And so it's beyond that 90 days, which means that you could have lead again if it happened. So.
Okay, so yeah, the lab, what I'm looking at is, the laboratory results from the interior. Nothing, of course, was tested on the exterior. It was just found to be that there was some areas of wood that were exposed where paint had peeled away. It wasn't that anything, failed by testing on the exterior. But the interior, the clearance examination report is here. And you just note some peeling paint on the exterior in some of these issues or some of these properties.
I don't think the exterior is an issue right now. If it is, Mr. Vanover can correct me, but I think it's the interior and not getting that in within 90 days that's the issue. Okay.
The interior, the interior on all of my properties, every test, all the swabs were done within the, before the expert, all the swabs of the interior were done, completed, and by the lab results, they all passed on the interior of all of these properties in question.
Were they sent in?
What was that?
Were they sent in?
Yes.
Everything met the timing for sending them in?
Yeah, so what I'm looking at is on the 5th of February of 2023 is when all this paperwork was signed. I was copied. Oh wait, let's see, the exam report will be a later date because that had to go through the lab.
Let me put you on hold for just a second here. Ms. Austin, for our board, has a question. I want to let her go ahead and address that in case it's pertinent to what we're talking about now. Ms. Austin?
Mr. Chairman, Mr. Ganglani and I have this question. Was the original clearance report presented to Building and Housing that appellant is testifying to?
Okay, so she wants to know if you had submitted this information on the interior.
I sure hope so. It's in the hands of, I mean, that's in the hands of the inspector to, to turn that in.
No, it's incumbent upon the appellant to have presented a clearance report to the building department under the code. Was that clearance report submitted to the building department? And maybe Ms. Freiermuth can answer that.
I'll defer to Ms. Freiermuth.
Yes, the report was submitted to Building and Housing in
Miss-
March.
Yes,
So
Mr. Chairman, to Mr. Fairmouth, was a complete lead clearance submitted for the structure in March?
No.
Rear,
it was not a
exterior,
complete
everything?
report. We had the exterior pending, which was result of the winter weather deferment.
Okay, so that's what I want to clarify. So there was not a
Okay,
clearance
so where on
report.
the report, where on your notice does it say that? Because, Mr. Chairman, Mr. Blaine Glani and I reviewed OAC 3701.32.-32-12, subsection E3, that says if portions have cleared, the only portions that have to be recleaned and tested are those that failed. So is the department saying that it was not a complete report and they couldn't review it? Or that portions failed? So we're trying to get understanding of what is before the board.
We are considering it an incomplete report at this time.
So, Mr. Chairman, the board then need to decide, is this an incomplete report that does not meet the state law that can be reviewed? And so the whole thing has to be resubmitted, which is what it sounded like you were leaning towards. I think that is the question before the board.
Yes, it is. And
So that would be the initial question. The board, would you agree? Mr. Ganglani and I agree that's the initial question this board has to determine is what is the scope of what's before the board? Is it an incomplete report such that the appellant has to resubmit a timely report of everything within the 90 days time? Or was it considered a complete report and only has to submit what did not pass? So that I think that would determine what the answer this board will be giving. You agree?
yeah, there wasn't any failure, I don't believe, so it was an incomplete report. And, I don't know how that plays in for the winter deferment, but it seemed to me that they were turning in the report just for the interior and the exterior wasn't done. But if that was a part of that deferment, I don't know, does that play in?
So I think when you answer that question, Mr. Chairman, in that ruling, it would decide the matter.
Mr. Chairman,
Mr. Ganglani, that's our
Okay,
our legal advice. Thank you.
okay,
Mr.
right.
Chairman.
yes, go ahead, Mr. Vanover.
So the OSC identifies how a lead clearance is to be conducted. The City of Cleveland codified ordinance expresses that a lead clearance is required to be submitted for all rental property in the City of Cleveland. So while the OAC lead clearance process informs the city process, the city is expecting a lead clearance. Unlike, as with any other process that's codified by the state, how they get there, they follow the state's rules. But our expectation is a lead clearance submitted. This ordinance went into place in March of 2021. And as with, I've said multiple times, these properties, rental properties in the city should be lead free or lead safe always. And there should be continuous work to be done to make sure that they are lead free or lead safe. So in this case, some 2.5 years after the ordinance has been in play, we are now with properties that are partially partially lead safe, partially not. And our expectation is that there is a finite document, which is a lead clearance from the state per the state's requirements, but submitted to us. That's why it's an incomplete document, incomplete report submitted to us. And that is in granting deference for the winter work. That's an attempt to be helpful, an attempt to work with property owners. But at the end of the day, the lead safe clearance was required March of 21. We are now in December of 23. And we do not have and did not have a lead clearance submitted to us. So I don't want the board to mix up the state's requirements for getting a lead clearance, the city's requirements for receiving one.
I do need to speak to the time frame as well. I apologize.
Mr. Santillo can further opine on what exactly our ordinance says, but ultimately we're expecting a lead clearance, as we would, Mr. Chairman, and the rest of the board, as we would with any other third-party inspection report. If I can use an example, that there's the ASTM standards and engineering standards will explain how the commissioning of a mechanical system gets done. But at the end of the day, under the Ohio Building Code, the requirement is that the department receive a commissioned system. And when it's put into service and prior to put into service. I use that only as an example of how the clearance the clearance itself is conducted is in part determined by the OAC, but the city of Cleveland is requiring the clearance report, and we're requiring it within 90 days of the inspection time. Thank you, Mr. Murphy.
I just wanted to speak to the time frame. I understand when this came into play. But for example, the property on Bucyrus Avenue, I thought I had the date here. It looks like I'm seeing in 2022. Let's see. I purchased it. I want to say that one was right around March of 21. Almost all of these properties that I purchased were neglected properties that were not being handled or taken care of in any way, shape, or form the way that I take care of my properties. So I had a lot on my hands to get up to speed, and I really honestly purchased all of these properties in the calendar year of 2020 into 2022. So some of them already I bought, from people who wanted to get out from underneath the lead thing themselves, and I took them on and said, I can, I'll abide by the rules. I'll do this. So,
and Mr. Chairman, if I may, I appreciate properties going into the hands of beneficial owners, but also those are, as I've stated before this board multiple times, that those are economic decisions, and the level of compliance for properties or lack of compliance always influences the purchase price. So those are business decisions. And as a property owner, all property owners, if they're not aware, should be aware of the requirements when they take possession.
Could I jump in, Madam Chair?
Yes.
Or I'm sorry, Mr. Chair, I can't see who's presiding today.
No, go ahead.
Okay.
No, we were going to get to you too, Councilman Harsh, to get your opinion on this.
Yeah, so I just have a couple quick questions. So, Mr. Murphy, I appreciate you going through the process of inspecting the properties. It is a requirement. I'm glad to see you doing it. Can I ask who was your lead risk assessor? Through the chair to Mr. Murphy, who was the lead risk assessor who did this work for you?
Charlie Herb or Harb?
Charlie Herb?
Charlie Harb, Harb, H-A-R-B.
Okay. I asked because I was a lead risk assessor. I did inspections for landlords and, Mr. Chair, the city's lead safe clearance requirement doesn't require any soil sampling. It requires a visual inspection and you must pass that visual inspection. And then it requires dust wipe collection on the interior units, bedrooms and living rooms and kitchen. But when I had a client that passed a visual, I didn't even bother sending in the lead dust wipes. I would just walk around the house and say, well, that's a clear violation. You're going to fail. And you don't need to pay me to tell you that. So if the unit is been corrected on the exterior, it seems that the solution here is to have a lead risk assessor go back out there, do another visual assessment, retake the dust wipes and resubmit, hopefully this time a passing lead clearance exam. I'm curious, Mr. Chair, to the inspector, did they submit a failing exam? Is that what caused this? They submitted an exam that was a failing exam?
I think it was incomplete. I think that's what
It was
we're
just
hearing.
incomplete.
Yes.
Okay. So, I think part of this is could have been avoided if your lead risk assessor had been a little more responsive with you through the chair to Mr. Murphy. Failed visual. I would never, when I was a lead clearance examiner, I wouldn't submit a failed visual, but it creates headaches that don't need to exist. But would have given you the opportunity to work with a contractor to fix that. And that seems like that process was skipped here. So I'll just wrap up here and let the board go about its business and however you see fit. But I'm inclined to agree with Commissioner Vanover. This goes back to March of this year. There's been plenty of time, and a lead risk assessor ought to be able to get out there pretty quickly to do another exterior visual assessment and some new interior wipes to determine whether or not the unit passes. But I do appreciate Mr. Murphy through the chair taking the effort to go through all of this. It is what is required, and I am grateful for that.
Okay, so what we have then before us is that that notice was properly issued by the department, and I believe that you're going to have it re-inspected, okay, and turned back in again with a good inspection in order to move forward on this. So I'm going to put that as the form of a motion for the board, and have the board see if they agree with that.
I agree. So moved.
Okay, moved by, go ahead, Ms. Davis.
Was there a second?
Second.
Mr. Bradley?
Yes.
Mr. Maschke?
Yes.
Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Okay, we'll have a notice will be sent out in 2 weeks. Thank you. We're going to go on to, you have 2 more that we're going to open up. So we'll go on to 3913 Bucyrus Avenue. That's A15723.
Mr. Chairman,
Yes.
please give the announcement that we are now down to 3 board members.
Okay, I'll do that. We only have 3 board members, which means that if our decision is not unanimous, which it usually is, then your appeal goes back to the city. If for that reason you prefer not to have your case heard, then let me know when we call your case that you would like to reschedule your case. Okay, so we're reopening docket A1, not reopening, we're opening docket A15723, 3913 Bucyrus Avenue.
This is a reopened docket for the notice of deficient lead letter that was issued on July 7th of 2023. We received it July 31st of 2023. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson, Law. Will the appellant or his or her attorney or representative please state your name for the record?
Yes, this is Ben Murphy.
Okay, I'm gonna swear you in and everyone else that's gonna be giving testimony again with this, but I'm wondering if without objection, if we should reopen docket A-158-23, 4016 Woburn Avenue, because I think we're dealing with all the same thing here. And rather than going back and forth, if there's no objection, then I would like to open up both of these dockets. So A-158-23, 4016 Woburn Avenue also. Ms. Davis?
It's gonna open the next time. Oh, sorry. Application and fees are in order. This is also notice of lead deficiency that was issued on July 7th of 2023. Appeal was received July 31st of 2023. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Would the appellant or his or her attorney or representative please state your name for the record?
Yes, this is Ben Murphy.
Okay, so we have on, I believe, still have on Mr. Murphy, Ms. Fairmuth, and Mr. Centilla, Mr. Vanover, and Councilman Harsh. So if you all solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Yes. Okay, go ahead, Mr. Murphy.
So as we were preparing to open these court cases back up here, I just did a quick look over these three properties, all of which I purchased in 2022. So I just again want to make that statement that I've been, sure there's a reason of my interest to buy investment property, as there would be for anyone, but when we're looking at the length of time in which property owners have to meet these standards versus the length of time that I had, along with getting tenants out of the property for me to be able to work on the property. I also submitted information with these cases originally that shows my communications with my painter ongoing, pleading with him to get to these properties and him reassuring me he's going to get to these properties and that they will be done on time. I did not want to go past this deferment time frame. I definitely, did not want to be in this position where I'm asking for an extension. So again, I'm still just requesting that, I understand that you can't grant this to everyone, but I'm hoping that my circumstances would be looked at and there's some leniency given in order to allow me to keep my existing interior samples that have cleared and passed as such. Clearance for lead safe interiors. My exteriors are done. I'd like my inspector who, as mentioned, maybe did this process in a way in which wasn't the best for me. And I have used a different inspector because I have had complaints with this inspector, but that's beside the point. I used someone else for a different property that I have after this experience with this inspector. So I know we're generally good for 2 years on the clearances, and I'm just again asking that my clearances on the interiors be upheld as cleared and that the exteriors can be looked at and then resubmitted and passed.
Okay, Mr. Murphy, on both of these interiors, both of them are considered or were put in as lead safe and not lead free. Is that correct?
The language says lead safe. I'm not sure how you achieve lead free versus lead safe. Is there a
you would have to remove all lead inside. In other words, there would be no lead, and that would be probably would almost take a complete, almost like a new build, where you would have no lead involved whatsoever, and they could state that it was totally lead-free. If that was the case, then we wouldn't have a problem because it's not going to appear again. It's not there.
Mr. Chairman,
Yes,
that would also require the inspection for a pre-1978 structure to be determined lead-free. That's also an entirely different inspection, considerably more intensive, and many more parts as
okay,
well. So just so that we're clear, this property was not inspected to get a lead-free classification.
okay, there you go.
And if I may ask, Mr. Chairman, to the appellate, what is the hardship of re-inspecting the properties for a current lead safe clearance and submitting that other than the cost?
Mr. Murphy.
Oh, I'm sorry. I thought he was asking. Other than the cost involved, of course, is a hardship. Scheduling with the tenants to get an inspector in there is just another item that needs to be done to make this happen. But the costs involved is the number one item because I have paid these costs already, and I did not expect to incur them again for another couple of years. That's mostly what it comes down to. But the fact that I've been believing that I'm doing my best to, work with the program this whole time.
Can I jump in here again?
Yes, you can. Go ahead,
Yeah,
Councilman.
Mr. Chair, I think this is the problem. So I think the inspector submitted incomplete reports, and I don't think you can go back and amend those reports once submitted to try to make them complete. I think the lead risk assessor made a mistake when they submitted these reports to the city of Cleveland. They were incomplete according to Inspector Freiermuth, which sounds, like it's a black and white issue. They were incomplete, and therefore they don't qualify to pass the lead safe certification. And the solution here is for Mr. Murphy to submit lead clearance that passes. I don't think there's any way around that. I don't understand there is no way to amend the report as submitted that I'm aware of. There just has to be a new lead safe certification submitted.
Okay,
Yeah.
thank you.
I found through questioning things that this inspector did for me and told me about this process to be completely false and fabricated, and so I guess I shouldn't be surprised to hear you tell me that, and that this is why I hired someone else to inspect a different property of mine, because I found some of the things that he told me about the process and were just off the wall, and I don't want to. If you want me to entertain you with them, I could verbatim, but
I submitted like 4 dozen lead clearance exams on behalf of clients before coming to city council. It's not terribly complicated. It should have been a conversation between you and the lead risk assessor first. And I would encourage you to look to any number of community development corporations, which are nonprofit community-based groups in Cleveland, that all offer either lead clearance examination services or can refer you to somebody reliable and trustworthy to help you with this process. It sounds like you made a good effort, but perhaps your clearance examiner or inspector wasn't really, working in your best, doing the best for you.
yeah, if there's any, that rebate program I would know was out. I don't know if it was called rebate or what, if there's any way I could participate in that would be helpful.
Reach out to the Old Brooklyn Community Development Corporation through the chair, to Mr. Murphy. Reach out to the Old Brooklyn Community Development Corporation. Alex can help you out. He works there. He knows all about this.
Okay.
Thank you,
Can we
Councilman.
make a motion?
Yes, we sure can. And once again, the notice is properly issued, and that the requirement is to have the 2 properties re-inspected for a lead assessment to come up with a safe report. Motion.
So moved.
Okay, moved by Mr. Dink, second by Mr. Bradley.
Mr. Bradley?
Yes.
Mr. Dink?
Yes.
Mr. Gallagher,
Yes.
Mr. Chairman, discussion.
Yes, go ahead, Mr. Vanover.
Ms. Davis, we request that the resolution include the language that a lead clearance that a complete lead clearance be submitted to the Department of Building and Housing as required by the City of Cleveland codified ordinances.
Okay, well, we'll include that in because that's exactly what the problem is.
Thank you.
And
Okay.
for me to clarify, this means I'm have no connection or attachment to this inspector. It doesn't make any sense for him to, his involvement isn't advantageous for any reason. Since he was already involved, it's not.
Mr. Chairman, this is Patty. The board can't advise on that. That's an appellant choice.
I'm sorry, I'm just, in terms of paperwork that's turned in, we have to completely restart paperwork, I guess is my best question for you.
I would say yes.
Because it's a complete new report, all fresh, just the way it would be if nothing had ever occurred on my properties. Is that where I stand?
From the city?
Yeah, from the city standpoint, yeah.
Yeah, Mr. Vanover or whoever wants to,
Mr. Chairman to Mr. Murphy, that is correct.
Thank
okay,
you.
there you are. Okay. All right, you'll get the notice out within 2 weeks. Okay, thank you for everyone involved here.
Thank you.
Mr. Chairman,
Yes.
we're gonna go back to docket A 22923, Mr. Uma.
You have them on.
It's
Okay.
on.
All right, we're gonna reopen the docket A 22923, 2407-2409 Coburn Avenue.
Application fees are in order. Notice of violation is fired. Issued on August 15, 2023. Appeal statement was received September 13th of 2023, requesting 180 days to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Will the owner or his or her attorney and or representative please state your name for the record?
James Omer.
Okay, Mr. Omer, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and let us know what your plans are.
Okay, so we recently received 3 to 4 estimates from different teams, and right now we're working with the insurance team to give a go-ahead that we could start the repairs and complete them as soon as possible. So right now we do have some violations on the property from the city, and we got an estimate on those items as well. So most likely in this week, we're gonna complete them, and we'll see as well that we have completed them and they can do the inspection on those items.
Okay. Mr. Vanover?
Mr. Chairman to the appellate, was this property occupied at the time of the fire?
Yes.
And Mr. Chairman to the appellate, I'm assuming this was a rental property?
Yes.
And Mr. Chairman to the appellate, is currently vacant?
Yes.
Mr. Chairman, the ask is for 180 days, and this notice of violation was issued in August.
Mhm.
So that would put 180 days at February. While I recognize that insurance companies can be problematic, we would not object to a time frame of the end of February, but we would ask that permits be in place relatively quickly. It sounds like the estimates are close and and that the contractor selection is close, so we would ask that application and the design for permits and for the repairs be made no more than 60 days. And that they allow the residential code of Ohio to dictate the time frame for the build.
Okay. Councilman Harsh.
Yeah, thank you, Mr. Chair. Through the chair, this property is owned by, looks like Clinton Straub with a tax mailing address of a commercial property in New York City. So through the chair, Mr. Omer, what is your relationship to this property, sir?
So I'm the property manager for this
Okay.
owner. Yeah.
And through what capacity, through the chair, Mr. Omer, do you act as property manager? I mean, I'm sorry, are you a real estate agent, a broker? Are you a sole employee of Mr. Straub's Ohio Holdings? What is your?
So I'm the property manager for B2B Property Management.
Okay.
That's the property management company.
Okay.
In
Mr. Mayor, are you a real estate agent or a broker?
No,
Neither?
no.
Okay. Are you through the chair, Mr. Omer, are you the sole property manager for all of Mr. Straub's Ohio Holdings?
Like 3 of the properties, I'm not. I'm the manager for them, but I'm not sure if they have any other property.
Okay. And Mr. Omer, through the chair, do you manage any other properties for anyone else?
Yes.
Okay. Well, Mr. Chair, this is just illegal property management. The state of Ohio laws are pretty clear. Property managers have to be licensed brokers, or they have to be the sole employee of the property management on behalf of the property owner, or they have to be a licensed attorney. I suppose Mr. Mayor could be a licensed attorney. I forgot to ask that. But I would ask this board to consider whether or not the appeal is even legal. If he's not a legal property manager, I'm not sure if he has legal standing to issue an appeal.
Okay, we'll go back to get maybe from Mr. Jacobson or from Mr. Vanover and to get a ruling on this.
Mr. Chairman, that would be your counsel that makes that determination.
Oh, it'll be our counsel, okay.
I'd like to
No.
hear arguments from the city, but Mr. Chairman, Ms. Davis is checking the file for the authorization letter. We have a moment.
Mr. Chairman, this is Dan Jacobson from the Law Department. The appeal was, part of the appeal in the documents, there's a property management agreement. And it is between Clinton Straub, the title property owner, and TH Group LLC. Through the chairman to the appellant representative, I would ask what is his relationship to the property management company, TH Group LLC?
Mr. Omar?
Yeah, so TH Group is a business name of Clinton Straub. And I represent B2B Property Management. We do have the PMA. And we are managing one of the properties for Clinton Straub, which is Colburn.
It sounds like, I'm sorry, is it P as in Paul or T as in Thomas H?
Through the
T as in Thomas?
TH, T as in Thomas, H as in Harsh.
Okay. So then it sounds through the chair like Mr. Straub has an agreement with himself.
No,
to
that's
manage
not
the
what,
property.
Mr. Chairman, we're looking at the agreement. That's not what this says. The agreement is clearly between B2B Realty as broker and Clinton Straub / and TH Group LLC. So Clinton Straub and TH, that's not, they're,
Okay.
if the councilman would like a copy of this, I'm sure the board will be more than happy to forward it after these hearings. But
Sure.
it is a broker agreement, and it does say B2B with it. Mr. Chairman, without having the luxury of time and research, We're gonna, Mr. Ganglani and I agree that to advise the board to accept it as properly authorized under this presented and continue forward with the hearing,
Okay,
appears
well, without objection from the board,
agreement.
we,
authorizing it.
all right, well,
Okay.
without any objection from the board, that's exactly what we'll do.
To the board, for clarification, the property management agreement is between B2B Realty and Clinton Straub and TH Group LLC.
I see. Okay. And who is, to the chair, who is the broker for B2B Realty?
Jad Budia.
I'm sorry, who?
His name is Jad. J-A. And second name is Budiab. It's B-O-U-D-I-A-B.
Okay, got it. Okay. Mr. Chair, this is why we're trying to work on agent in charge legislation, because it sounds like Mr. Umera is not, the broker is the person who's supposed to take responsibility for property management, and only the broker. And they're not supposed to be representing multiple clients if they're not a broker. And so this is part of the mayhem that we have right now, because we don't have enough laws in place or appropriate enforcement to try to keep this from going haywire. But I will dip out by saying that I agree with Commissioner Vanover. If this was issued in August, I'm sure the fire was before that. They've had plenty of time to work on this, and should just adhere to the laws already existing in Cleveland.
Okay.
Mr. Chairman,
Go ahead, Mr. Vanover.
one final comment. This is a corporately owned rental property that is not registered as a rental property, at least under the address of 2409 Colburn. So we would ask that
Yes.
any time granted, I would like to restate. This is a dual address of 2407 and 2409. Is that correct, Ms. Davis?
Yes.
To Mr. Chairman, to Mr. Vanover, that is correct.
Okay. All right. So I stand corrected. 2407 Colburn is registered and is renewed. However, as a corporately owned rental property, we would ask that any time granted is kept very short. There's an expectation when you are a commercial enterprise in the business of real estate that you have resources in place to handle these conditions when they arise. And that may include having known contractors, having, the ability to work with insurance agencies to get this done sooner than later. So we ask that any time frame be kept very short, and that the expectation for permits and permit applications be even shorter. Thank you.
Okay, I believe when we looked at this, we can do like I don't know if there needs to be a structural, probably drawings sent in for this, along with getting the permits. So we can go with say a March 5th date for getting permitting in, and a February 2024 and a March 5th date 2024 to do any of the structural drawings and whatever else needs to be done. Is there a motion?
Mr. Chairman, can you say that again?
Yeah.
I would, yes, February 5th to obtain all permits, 2024, March 5th, if there's structural drawings and whatnot needs to be done, 90 days, 2024 to complete those and send them in.
Mr. Chairman, though, if I may, any structural or architectural plans will be required prior to the permits being issued.
Well, then let's go with, if that's the case, then let's go with the March 5th, 90 days, 2024 to submit the structural.
Mr. Chairman, the city objects to that time frame. That would be, that'll be 6 months that it's in this condition. I think that those plans can be submitted sooner. We would ask that the abatement be completed around that time.
Okay, if that's the case, then, I don't know how quick they can get drawings done, so, we can jack that back to, say the February 5th date, 60 days to, 2024 to submit the drawings to, you know, 'cause I think it takes a little time to get them together. I don't have, well, maybe Mr. Denk knows, but, I know Mr. Massey would
Like
definitely.
that,
What's that?
60 days was mentioned earlier in the testimony as being a proposed time frame for registering for permanent, and that sounds like a reasonable
Okay,
result.
all right, let's
So
do that. Go ahead.
I'll make that motion.
Okay.
60 days to submit for permit.
Okay,
No,
that's it.
Mr. Chairman,
Yes.
Mr. Chairman, we would ask then if it's.
There was a motion on the floor, Mr. Chairman. You had a motion on the floor, Mr. Chairman.
Well, we had a
Mr. Chairman,
motion,
under the
but
Roberts Rules of Order, you have to have the motion accepted and seconded before discussion. Thank you.
okay, is there a second to the, February 5th, 2024 date? Mr. Bradley?
Yes.
Mr. Bradley has second.
Okay, all right, discussion.
Mr.
Well,
Mr.
we
Bradley,
got a second. Hold on,
Mr. Dink,
hold on,
Yes.
hold on. Get Mr. Vanover. So it's been,
I believe you have, I believe you have to address your, motion, Mr. Chairman.
well, we've got a motion out there, as far as, it's been moved and seconded, and we can't
Okay.
have discussion before we have a vote. Okay? That can happen.
Good.
Correct me if I'm wrong.
No,
That's
that-
correct,
that-
Mr. Chairman. You've moved and seconded it, and you are allowing a discussion for Mr. Vanover's objection.
That's exactly right. Mr. Vanover?
Mr. Chairman, we ask that if the motion is that plans are submitted for permit February 5th, that you provide a date certain for the abatement of the violations.
Okay,
Mr. Chairman, to Mr. Vanover, just for clarification, that would then, you stated, and I thought it was reasonable, that would then proceed under the Ohio Residential Building Code.
Mr. Chairman and Mr. Dank, that is correct if the motion was for the permits to be obtained by February 5th, then that would be accurate. But with the motion being that they are submitted by February 5th, it leaves it open where the appellate could just not respond to adjudications and not respond and not follow up and not, I mean, the process could, it could, under that same residential code of Ohio, it could be another year and a half before permits are pulled, and then whatever time frame to actually get it completed.
Yeah, okay.
well, if you want to amend the motion, Mr. Dank, to include permits for that date, that all of it's going to be done around the same time, and then that would allow the Ohio code to kick in.
Can the motion be amended to require permits to be obtained in 90 days?
Mr. Chairman, can I make a suggestion? This is Patty. If
Yes,
the-
go ahead.
If the concern is that that it would languish, the board could add some sort of failure to request a continuance or any writing by within 30 days thereafter, by the March 5th date, it would be remanded to the building department. Mr. Dank is correct. The administrative process under the RCO, similar to the OBC, governs that. So that's part of the administrative process. If it requires the drawings, then that due process is covered under the Chapter 1 of the RCO.
So you're saying that by the February 5th date, we're covered?
I think
by-
you're covering everything by the February 5th
Okay.
date.
Okay.
Mr. Chairman, my
go
question,
ahead.
my question is simply, if the motion is to submit for permits by February 5th, There is no further requirement from this board for the appellant to do anything. They have satisfied the requirement of the resolution by simply submitting. There's no requirement to comply. There's no requirement, and yes, Mr. Chairman, Ms. Aston is correct. But that administrative process could possibly end with discarding the plans in the application for no further communication with the owner. The property is still not fixed. It's still not corrected. But they have satisfied the requirements of the resolution by simply submitting. I believe that the simplest thing to do is maintain the motion as it stands and then provide a date certain. We would not object to April 5th for complete abatement of the violations.
Okay, so they would have to get the permits then in order to accomplish that for sure.
That is correct.
Okay, we can do that. So we can amend the motion, Mr. Dank, to be we're going to stay with the February 5th date and have a completion date of April 5th, 120 days, 2024 as an amendment to the motion.
So moved.
Mr.
Bradley?
Yeah.
Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Thanks, everybody. Have a great day.
Okay, thank you, Councilman.
Mr. Chairman, we're going to move to docket A-14023. We have, look like we lost her.
Okay, docket A-14023, 7506.
I take that back. It looked like she left.
Oh, she left. Okay. All right, we'll go back to the top then. If she comes back, we'll jump over to pick it up. Okay, so if we're back to the top, I think we're at A-13223, 2221 East 76th Street. That's the rear house.
Application fees are in order. Notice of violation is no permit, interior and exterior maintenance, and rental registration. Issue May 10th of 2023. Appeal was received June 10th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name and relationship to the property?
Morning, my name is Gabrielle Alexis. I'm the managing member for Family Dynamics, which owns the property. I'm the sole member.
Okay, Ms. Alexis, solemnly swear to tell the truth, the whole truth, so help you God?
Yes, I do.
Okay, go ahead and let us know what your plans are.
There were 3 citations issued. I obtained the registration, the rental registration that had expired. I renewed it. For the items, I think about 28 of them. Everything has been done except the number 19, which is the driveway. Now the big problem is the permit, because I bought the property in 2020, December 2020. I was not the one that added that laundry room. I didn't know that it was added without a permit. It's been quite difficult getting a contractor to do the design and just to try to get the permit. I was told we could get a permit and show that the work was done because I purchased the property like that. It's been really difficult and a lot of hardship. because that property was, I mean, I had a tenant, which is also paid by Eden, and for 5 months we were not paid. And, but all the work has been done. Eden passed the inspection and except for the driveway that we need to fix. And I'm hoping that I can probably get 45 days to get the permit pulled. Right now, the permit is the biggest issue. The driveway can be done by next week. But getting the permit, the kind of money they're asking for, has been kind of difficult. That's why I'm asking. And in the meantime, we had a busted pipe that cost $12,000 between water and sewer to be paid. So it's been quite difficult because I'm a small company. I'm the only member, so it's just costing more money to manage a property.
Okay, let's go over to Mr. Vanover.
So, Mr. Chairman, there are 3 notices of violation issued. Addressing them in order, this property is currently registered. The registration has been renewed. And then moving to the interior exterior maintenance violation, there's no record of any inspections having been conducted to verify that the work is complete. We would ask that any resolution require it to be re-inspected within the next 2 weeks to verify that condition. And we don't object to more time for the no permit, provided that time, if providing that time period is a very short period of time. It appears that it is an economic decision. And as I've said before, the conditions of properties are influenced. The cost of property when it's purchased is influenced by the condition of the property. So we would ask for very short periods of time for the no permit and a requirement that the interior exterior violations be inspected.
Okay, so we're going to require the a re-inspection or inspection of the property, and I guess what was ever done there without the permit to be able to see what can stay and what has to go. You were asking for 45 days to complete the driveway, and so we can give you the 45 days, and then you can get the reinspection done within that time frame, and see how we make out here. So we're looking at January 20th, 45 days, 2024 to abate the violations, and to December 20th, 2023, 2 weeks to get it re-inspected inside interior. Motion?
So moved.
Okay, moved by Mr. Dank. Second by Mr. Bradley.
Mr. Bradley?
Yes.
Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Okay, notice is going to be sent out within 2 weeks. Thank you.
Thank you.
Okay, next docket is A-134-23, 3243 West 32nd Street.
Application and fees are in order. Notice of violation is no permit, interior and exterior maintenance. Issued on June 9th of 2023. Appeal was received June 29th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, and Jacobson Law. Will the appellant or his or her attorney or representative please state your name for the record?
Good morning. My name is Christopher Mulvaney. I am counsel for KTC Properties.
Okay, Mr. Mulvaney, solemnly swear to tell the truth, the whole truth, so help you God?
Everything that I say will be true to the best of my knowledge, based on representations by my client.
Okay.
All right. My client has 2 requests on this matter. First, with regard to the interior and exterior violations. we'd request a extension until April to ensure all of those are corrected. We understand that the notice was filed several months ago. However, the property is currently occupied by tenants. We attempted to work extensively with them to get their cooperation in allowing us access to make the repairs. That has not been successful, and my client has begun the eviction process. However, given the speed at which the docket moves, that could take at least 2 months before we're able to actually get possession of the property back. I would note that the property is registered as a rental and does have a lead safe certification filed with the city. The second issue has to do with the illegal occupancy violation, which I understand is based on the records of the city of this being a two-family property. My client purchased the property back in 2009 when it was advertised and sold as a single-family dwelling, and it has been used as a single family the entire time that my client has owned the property. On receiving the violation, he went to the building department to see what he needed to do to correct the issue. Was told to pull permits, but he can't pull permits for work that he hasn't done. So with regard to that aspect, we'd request that it be reclassified as a single family property, or the alternative, if the board can provide us information sufficient to allow us to get that change made.
Okay. Go over to Mr. Vanover.
So, Mr. Chairman, the board, I will assert that the board does not have the authority to reclassify the property. That the property gets reclassified through a plan approval, submission to the city through a plan review from the city, and that any work, unpermitted work, has to be permitted. With registered contractors, per the City of Cleveland codified ordinances and the Ohio Administrative Code. So that's how the change of use gets done. The board does not have the authority to grant that reclassification. And we don't object to more time, but again, we ask that time be kept to a minimum. There are tenant landlord laws that grant landowners the authority to work on their property while they're occupied. This is the nature of the investment property business.
If I may briefly?
Yes, go ahead, Mr. Mulvaney.
One of the concerns when we attempted to pull permits is my client didn't do any of the work. So we don't know what work was done to convert this property into its current configuration. With regard to the issue with the tenants, as anybody who has had to deal with residential tenants knows, if they are not cooperative, the ability to compel them to be cooperative with repairs is very difficult and can effectively stop work from occurring, as we don't want to create a breach of the peace, which is why we are moving in the direction for an eviction. And to the extent the board may wish it, we would not have any objection to, once the property becomes vacant, not re-renting it until all violations are cleared.
Okay, so the issue is going to be time to accomplish this.
Mr. Chairman?
Go ahead.
To address the first issue, while your client may not, to the appellate counsel, while they may not have completed the work, the expectation would be that they hired a design professional to determine what work was completed, to design the new configuration, to identify what work needs to be represented by licensed contractors, as well as, and then have permits pulled accordingly. to have the work inspected, for a registered contractor to take responsibility for the work, make corrections that are required under those inspections. It is the responsibility of purchasers of property, when they're preparing to take possession of property, it is their responsibility to do their due diligence, to make sure that permits were applied for, to identify which work is new, to find what the last legal use of the property was prior to purchase. Simply buying something in a condition and saying it wasn't me is not an acceptable course for this. This work needs to be permitted prior to the use being changed. And I'll just restate, I understand that working with residential tenants can be difficult, but that's why the business is as lucrative as it is. That's why these are business decisions that are made. There are many different businesses in this country one can engage in, and each has their inherent risks and rewards. So leaving the property in this condition because of the decisions of which risks and which rewards the property owner is engaged in is also not an acceptable course.
So how much time are you looking for, Mr. Mulvaney?
We'd look for an extension to at least April. Part of the issue is identifying and hiring the design professional, and then identifying the contractors who could take responsibility. My client has attempted to discuss the issue with the building department multiple times prior to today, and this is the first time we've heard that that is the steps necessary to accomplish that. The previous representations by the building department were to appear before the board and ask the board for the permission. So if Mr. Hanover is stating we need to hire a design professional and identify the contractors to identify the work that was done, those are the steps we will take. And we have been attempting to work on this since we found the notice of violation was issued.
Okay, on the issue of time, Mr. Vanover.
Mr. Chairman, this is a corporately owned rental property, and we ask that any time be limited. I restate that the due diligence of the property owners it's their responsibility, and that it should not be the burden of the citizens of the city of Cleveland to identify the due diligence required for corporate property owners. So we ask that any time frame be limited.
Okay. All right, so we'll go March 5th, 90 days, 2024 to abate the violations. Motion?
So moved.
Okay, moved by Mr. Dank. Second. By Mr. Bradley.
Mr. Bradley? Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Okay, notice will be sent out within 2 weeks. Thank you.
Thank you very much, John.
Mr. Chairman?
Yes.
We have the representative for council, Kathleen Mercer, back on for docket 14023.
Okay, we'll open up docket A 14023, 7506 Spafford Road.
Recess the long slide. 14023. This is application and fees are in order. This is a permit extension request. That was filed for under permit issued under P 20023-964. Appeal was received by this board on July 10th of 2023. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson, Law. Will the appellant or his or her attorney or representative please state your name or your relationship to the property to the board? Oh, Mr. Chairman, I do not see Sassy Marks in the participating panel.
Okay. Mr. Jacobson.
To the board, I see that the councilman's representative is present, and before making any comments, I'd like to hear any comments from her this time.
You want to hear that? Okay.
Yes.
Okay, we can do that. Miss Mosier, you want to go ahead and make your comments?
Hi, good morning. I'm here representing Councilwoman Rebecca Moore.
One second, Mr. Chairman.
Yeah, we got to swear her in, right?
Right, yes.
Okay. Well, solemnly swear to tell the truth, the whole truth, so help you God?
Yeah.
Okay, go ahead, Miss Mosier.
All right, this is a property that we've been following for a little bit and working with demo on 7506 Spafford. It's in pretty rough shape. It's been in pretty rough shape. This property owner acquired it, I think, back in 2012, and it's pretty much been left to sit and rot since. And I think this was the final permit that was getting closed on it, which is now being appealed. So that's kind of where we're at.
Okay. Mr. Jacobson.
Through the board to the councilman's representative, has there been any contact with Ms. Marks, the property owner? I say that because Ms. Marks, as part of her appeal, filed not really an appeal statement, but just documents a bill and a status of eligibility for a Disabilities Act. I don't know if you had access to those documents, and I'm not sure how they relate to the appeal, but without Ms. Marks being present to inquire about that, I wanted to ask if you or your office had any communication with the property owner and know if she's living there or not.
No, so we have not been able to get in contact with her, and to my knowledge, she's living on West 44th in a different address. This house is not. It's completely boarded, not in living condition.
Well, to the board, we would ask that the matter before the board is just it looks like a closure of the permit, the last permit. We would ask that be upheld and the matter remanded back to the Department of Building and Housing for further action.
Okay. I would absolutely agree with that. Yes.
Well, and for the record, I wanted to state through the board to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
To the chair, to Mr. Jacobson, no.
And then through the board to Ms. Davis, have you received any form of communication on the form of an email, voicemail message, anything, or physically delivered to you on behalf of this appellant?
To the chair, to Mr. Jacobson, no.
Well, to the chairman, the due process requirement of notice have been given to this appellant. The board can proceed with its hearing and its ruling today. Thank you.
Was that a question for?
No, that was just a statement that,
Oh, the
board-
statement. Okay, we're okay then. All right. All right, let's go over to Mr. Vanover for what I believe he's going to say. I already know.
Yeah, Mr. Chairman, this is a condemned property. This permits were pulled at the end of, began at the end of 19 and were pulled in 2020. There's been no inspections, there's been no compliance. And on those permits, the citizens of the city have paid to board this property up at least twice since it was condemned. And we ask that that you uphold the closure, the invalid permit letter on this plumbing permit, and remand all matters back to the department.
We uphold the violation notice and a motion is in order.
Mr.
to deny
Chairman?
the- Yes.
I'm sorry, it's not a violation notice. If I apologize, it's the closure of a permit.
You're right. So, yeah, no reopening of the permit, and they were asking for additional time, I think, was what their request was, but, we're gonna remand the property to Division of Building and Housing for any further action. Motion?
So moved. So moved.
Second.
Okay, moved by Mr. Danks, second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Okay, it hits back up towards the top, I believe.
Notice will be sent out at the next official meeting.
The next official meeting, okay,
Yes, in 2 weeks.
in 2 weeks, okay.
I don't want people even calling me asking about no resolutions, because it will not be in 2 weeks.
Okay, yeah, right on. Okay, we do, let's see, housing docket A-135-23, 3589 West 50th.
Application and fees are in order. Notice of violation is interior and exterior maintenance and no permit. Issued on May 24th of 2023. Appeal statement was received June 20th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson Law. Will the attorney or his or her, will the appellate or his or her attorney or representative please state your name and your relationship to this property?
Hi, this is Joshua Thomas, the trustee for the family trust that is owned.
Okay, Mr. Thomas, solemnly swear to tell the truth, the whole truth, so help you God?
Yes.
Okay, go ahead and proceed.
Yes, so this violation originated from a non-paying tenant who is trying to avoid eviction. I live out of state and have had a lot of difficulties with management. The original manager didn't act on these violations. So I transferred it to a new manager who didn't work out either. And I'm working with a third now who has been working diligently on all the non-permitted work. And so those items are just about complete. Regarding the permits required, all of the work requiring a permit was done 10, 15 years before I purchased the building, just 2 years ago. So I'm having difficulty finding any contractors willing to take on this permitted work at a reasonable price. And so the furnaces are almost at the end of their life. And so I'm supposed to get a retro permit for them. And it's difficult. And also the electrical panel issue is that if they touch the electrical panel, they have to bring the entire building up to current code. And this building is built in 1920. So in closing, I'd ask the committee for a 180-day extension as well as leniency requiring these permits, just since it's an extreme hardship and it's prohibitively expensive for me.
Hey, Mr. Vanover.
Mr. Chairman, to Ms. Davis, can you provide me the address again? I apologize, I missed it.
I'm sorry, the address is 3589 West 50th Street. Did you want the violation number?
I have it, thank you.
Okay.
So, Mr. Chairman, as I've said multiple times today, there is an expectation that the permitted work be inspected. When purchasing the property, it is incumbent upon the purchaser to verify that work that requires permit gets permitted. I will ask, Mr. Chairman, to the appellant, have you received a quote on permitting the work? You said it's cost prohibitive to do it. Have you received a quote for that work?
Yeah, it's about a fourth of the price that I paid for the entire building.
Mr. Chairman, to the appellant, have you had a design professional look at it? Because without knowing the intricacies of this, the Residential Code of Ohio does not require that the entire structure be brought up to code when you replace a panel.
Okay, maybe it was just the one contractor that told me that, because they said that if they touched the panel, that all the wiring needed to be gutted and to replace everything.
Mr. Chairman, I will state that just again that without knowing the intricacies of this design and the work that is involved here, that is not the way that the Residential Code of Ohio is written. This provides further pause if the electrical contractor is saying that the installed panels, that the wiring on the installed panels will not, the wiring will not support the panels, or will not support the load, or will not support the conditions. That's even more reason to have the work submitted, approved, and inspected. As to, again, this is a third-party conversation between the appellant and his contractor, but if the contractor believes that it's dangerous without replacing the wiring, I would think that, I believe that is more reason to require it.
That's not what the contractor said. They just said that if they were under the impression that if they changed the panel, that all the wiring in the area of that would need to be changed due to the code. It wasn't anything to do with the safety. The actual reason this panel was, I think, is such an issue. I'm not exactly sure why it's even an issue to begin with. It's just when the inspector came in, they said that there was no notification, no prior permit on this, and also the furnaces. I don't even see. Okay, you have a picture of the furnaces there. I mean, they're really old. So it's yeah.
So, Mr. Chairman, if the ask is to not get or work that requires permits, get permits, we object, and I think the board will too. If the statement is that the furnaces are not old, or were permitted, or were properly installed, that's a different ask altogether.
These new furnaces,
I mean, they were installed probably 10, 15 years ago.
oh, okay. So you think their life is about done, huh? Okay.
I do.
Well, how much time are you asking for? You said
180 days.
180.
Through the board to the appellant, Mr.
Yes.
Thomas, and then also through the board to Mr. Vanover. I note that there is a smoke detector. Part of the violation was a smoke detector is not installed. And I believe the appellant stated that there's a currently occupied structure. Can we clarify if it's occupied or not, and whether or not smoke detectors have been
The
installed?
smoke detector has been installed, and it is occupied.
Is it two family?
It is a two-family residence. One of the unit that's connected to the basement is occupied. The top unit where the original violation was requested is vacant.
I'm gonna go back to Mr. Vanover.
Mr. Chairman, I mean, we require that the permits be pulled, that either a design professional or a, contractor evaluate the property and properly pull the permits. That's our ask, and that that you uphold the violation notices and that the work be completed as required.
So if we require that the permits be pulled to whatever wasn't permitted, or whatever needs to be done with the property, give you, say, 30 days to get the permit pulled. And I guess we have to do an end date. Depending upon, we don't know what we're gonna run into here. Let's say April 5th, 120 days, 2024 to abate the violations. So 30 days to January 5th, 2024 to acquire the permits, and April 5th, 120 days, 2024 to abate all the violations.
So moved.
Okay, moved by Mr. Dank, second by Mr. Bradley.
I'm sorry, Mr. Chairman, can you repeat those dates for me again?
Sure. January 5th, 2024, 30 days to obtain the permits, and April 5th, 120 days, 2024 to take care of all the violations.
Thank you. Mr. Bradley?
Yeah.
Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Okay, the notice will be sent out. What did you say? We can't say 2 weeks, whenever.
A next official meeting.
The next official meeting, the notice will be sent out. Okay, thank you. All right.
Mr. Chair,
Yes.
this is Attorney Eric Allen. I have to, I sent a chat. I have to step away for a second.
Okay.
I have 2 cases on the docket.
Okay, you need to get moving. We can move you up, Mr. Lane.
I would appreciate that.
Okay. Let's see which ones we have here.
I have 239-23.
239-23. Okay, got it.
And then 240.
Okay, there's one right after the other. Okay, very good. All right, so we'll move on to docket A 239-23 9008 Tioga Avenue.
Application and fees are in order. Notice of violation is no permit and interior and exterior maintenance. Issued September 8th of 2023. Appeal was received September 20th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson, Law. Will the appellant or his or her representative please state your name?
It's Attorney Eric Allen.
Okay.
Attorney.
Okay, Mr. Elaine, solemnly swear to tell the truth, the whole truth, so help you God.
I do, thank you.
Okay, go ahead and let us know what your plans are.
This is a request for additional time. We're looking at we'd like to be able to pull the permits by the end of January. And then we're assuming that the work will be done sometime by the end of April. There is a tenant in place that's currently subject in the to litigation inside of the Cleveland Housing Court. We're working with everybody to do it, but we believe that there's going to be some delays on getting this done.
Okay, Mr. Vanover?
Bear with me. So the request was January and April, but it is occupied. Is there an expectation of when it will no longer be occupied?
There's a hope. The hope is that it's not occupied as soon as possible. The expectation in today's current environment, I don't think anyone can truly comment on that.
So, Mr. Chairman, there is an active rental registration. There is a current, appears to be a lead safe certificate pending. So that has been submitted. This is a corporately owned rental property. And as I've said before, tenants come with this business. Some are very good, some are less than good, but they're all part of the business. We would ask that that once the property is vacated, that it remains vacant until the completion of all the work.
No objection to that.
Okay, so motion is in order for like a February 5th, which would be 60 days to obtain the permits 2024, and June 5th, 180 days 2024 to abate all the violations and the properties to remain vacant until all violations are taken care of. Motion? Okay, moved by Mr. Bradley.
Second.
Second by Mr. Dink.
Mr. Bradley? Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Okay, notice will be sent out by the next meeting. And see, we'll move on to the next docket, A24023, 931 East 147th Street.
Application and fees are in order. Notice of violation is interior and exterior maintenance issued on August 30th of 2023. Appeal was received September 20th of 2023 requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson, Law. Will the appellant or his or her attorney or representative please state your name for the record?
Yes, Attorney Eric Allen on behalf of Cross K.
Okay, Mr. Allen, solemnly swear to tell the truth, the whole truth, so help you God.
Yes, thank you.
Okay, go ahead.
This is a similar situation to the last one. We're looking till February to pull any permits that are required, April to remove, to take care of the violations. This one is tenant.
Continue.
Well, we're getting some feedback there from somewhere. I think Mr. Elaine had dropped off. We're back with us. I think we lost him for a minute.
His mic went mute. Hold on.
Can you hear me?
Okay, we can hear you now.
Thank you. I think I got kicked off there for a moment. If I may, I'll restart.
Go ahead.
I think you heard that we were looking for the February and April dates. This one is occupied. It is the topic of an eviction currently in Cleveland Housing Court. Mr. Vanover asked if we had an expectation on this one. We do actually have one. The tenant is represented by legal aid, and we're currently looking at February 1 for her to vacate. We would have no objection to keeping it unoccupied until remediated.
Okay, Mr. Vanover.
Mr. Chairman, to council, is this the same owner or is this a different owner than the previous one?
This is a different owner.
So, Mr. Chairman, again, I'll restate that, you know, tenants are part of the business. The expectation is that the properties are maintained while they're being occupied prior to the citizens of the city are needing to pay an inspector to go out and do the inspections. With that, I will defer to the board for recommendations on time. However, this one does not have a no permit. This is a complaint and a violation notice for interior, exterior. I will also note that the rental registration for this property, according to my records under this address, has been closed. Typically meaning that some indication that it became not a rental, or through some information provided, we would ask that the property be registered as a rental with the city of Cleveland within the next 2 weeks.
Okay.
If I may comment on that.
Yes, go ahead.
I have no issue with trying to get it, the rental registration. We've already been working on that, but I would ask that with the holidays and that nature, we be allowed at least on paper till January 15th to get the rental registration squared away.
Additionally, through the board to Attorney Allen, I note that the property is currently occupied and that part of the violation was that the smoke detectors were taken down. I would ask that smoke detectors for the winter approaching be immediately installed or verified.
We should be able to do something with that. We need to go through the tenant's attorney to even gain access at this point, so we'll send off information on that.
Okay.
Mr. Chairman, rental registration is part of, I mean, that's the business. So it's disappointing in all cases where we have to communicate to corporate property owners that they need to comply with the ordinances of the city. So I don't see any value in granting any more time than the 2 weeks that I've already recommended.
And if I
Mr.
may
Chairman,
follow
this
up
is
on that.
Patty Mr. Chairman, this is Patty. Was that cited in the code, in the violation?
I don't think
before this board?
it wasn't.
Mr. Chairman, to Ms. Aston, it was not, but if the board is going to grant more time to make corrections, I think at minimum that they should consider the fact that the applicant is not currently complying with other laws required by the city of Cleveland.
Okay, Mr. Lane, you were going to say something?
Yeah, my understanding is that the rental registration was paid for, and my client is trying to figure out why it was closed in the first place. And we've been in communication with Miss Harris amongst I forget the other lady's name over there, to try and figure out why it's not showing up on the system.
Okay. We'll give you to January 15th, realizing that the property is going to remain vacant until everything is complete to take care of that, the registration. And February 5th to get the permits, and June 5th, these are all 2024 dates to abate all the violations. Motion?
Wait, this discussion,
Go ahead.
Mr. Chairman.
Yes.
So the January 15th, 2024, what date is that for?
That is for obtaining the rental registration. Somehow it got fouled up, and
Mr.
so
Chairman, that matter was not before us today. That's not one of the appeals, though.
It was not, no, but Mr. Vanover has asked us if we could include that in there.
We can include that? Okay, so January 15th is for rental registration.
Yes.
February
February 5th is to attain all the permits and 2024, and then June 5th, 180 days, 2024 to abate all the violations.
Okay.
And if I may, for the record,
Go ahead.
we don't have objection to including the January 15th date.
Okay. And also, it is to remain vacant until all the violations have been taken care of.
Yeah, it's not an issue. Thank you.
Okay.
So moved.
Moved by Mr. Dank.
Second.
Okay, second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes.
Okay.
Okay, so by our next meeting, you'll be notified.
Thank you.
Thank you.
Thank you, everybody. Have a great day.
Yes, you too. Okay, we're heading back up to the top, I think, somewhere.
Keep trying.
Wherever the top is.
We should be at 142.
Hopefully I crossed all this off. Okay, the next docket, I think it's 13923, 18321 Paramount Avenue, which has been withdrawn. Okay, so we're gonna move on to docket A 14223, 3201 West 41st Street.
Application and fees are in order. Notice of violation is condemnation of the main structure issued June 27th of 2023. Appeal was received July 13th of 2023, requesting for time to abate the violation. Present for the hearing, Tom Vanover. Department of Building and Housing, Dan Jacobson Law. Will the owner, would the appellant or his or her attorney or representative please state your name for the record? This was just one of three. So the other ones must have been. Okay. Mr. Chairman, I do not see Mr. Yassin.
Okay. Well, let's go. Mr. Vanover solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay, Mr. Jacobson.
Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
To the chair, to Mr. Jacobson. This board sends out 3 notices to the appellant. The board did receive back 1 of the certified notices. This says left notice. I'm not quite sure what the other, on July 8th of 2023.
There were sent notices 3 times. This, Mr. Yassin, and 1 he had to sign for. It was a.
I'm sorry, Ms. Smith, do you have something?
I'm
Are
so
you in
sorry.
relationship to this docket?
I do, as I'm the housing director at Metro West Community Development Organization at Councilwoman.
Could you please give us
I'm
1
sorry.
second, please?
Yep.
Okay.
So, Mr. Chairman, according to what Ms. Davis has stated regarding the board's record, 1 of the 3 notices was returned to the board's file, but the other 2 notices were not, have not come back. So this board determine based upon that information if you want to proceed or not.
Yes,
So,
we will proceed. And so that I understand though, but this, someone had said something that mentioned, I didn't know.
I'm
if they were
not
part of
quite
the
sure
property.
who Miss Smith is.
Okay, what we can find out, let's find if she's claiming to be a representative of this property.
She said she's with Metro West, so I guess it's a CBC.
Yep.
Is that one of our CBCs? Okay.
I have no idea.
It's one of our community development operations.
Oh.
Let's find out from Miss Smith. Miss Smith.
Yes, hello.
Now,
sorry for the
wait a
interrupt-
minute, before you start, hold on. I'm just asking, are you here for docket A 14223?
I am.
You are, okay. Then solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, and we're gonna find out who you are then as far as this property, what your involvement is in the property.
Yeah, I am the housing director at Metro West Community Development Organization. And we were requested by Councilwoman Santana to go out to 4 of the properties that are in these hearings today. And just look at them and see, what we thought about it and what we saw. And when we arrived to this property yesterday to take a look at it, we met Mr. Yassin, who is the owner, who the house appeared that he had taken care of a lot of, he replaced steps and porches, and we could physically see that. And it appeared that he's been making, acting in some kind of good faith from what you can see on the outside. And he also stated that he had not been notified of the hearing.
Okay, let me stop you for just a moment here, Ms. Smith. So you are a representative of the Councilwoman Santana, is that correct? Okay. All right, so what we were looking for is an owner or Mr. Yasmin or somebody representing him for this particular case. So I believe we were checking to see if he got the notice for this is where we were at with this. And if somebody for the property is not present, then we're going to have to go back and talk to the
Understand.
the building. Okay.
Yes.
So let's go back up just a minute here. We heard your comments, but let's find out on this issue of they were property notified. Where are we on that?
Mr. Chairman, Dan Jacobson from Law. I would ask that this get rescheduled. I believe Ms. Smith has stated that she spoke with the property owner. The property owner stated that he did not have notice to her. Can I correct that? Can I hear from Ms. Carroll?
Yes, that's correct. That's what he stated.
Okay.
Well.
Okay.
With
Well, that's
that,
simple enough. Let's do that. Let's reschedule him so that if he claims that he didn't get notice, we can do that.
Mr. Chair, to Ms. Smith, how did you get in contact with the owner?
Councilwoman Santana sent a request to our office and to please just go by the properties and to be present to be sure that we were here in the hearings, and we did.
I understand it. How did you contact the owner?
We did not.
If we could get in contact with him, how did you get in contact with him to meet him at the properties the other day you stated?
He didn't meet us. It just by chance that he arrived at that property at the same time myself and my housing specialist did yesterday.
So it was personal contact at the property.
Yes.
Okay.
through the board to Ms. Smith, how did you identify him as the property owner?
His name is Mr. Yassin, Amina Hassin, that's who he identified himself as.
Okay. I have an email address. I just thought maybe they had called him on the phone. That's why I was trying to get clarification. Because we don't have a phone number for him. And he gave us an address. So I just want to verify if he gave us the proper information to get in contact with him. Okay. Okay, Mr. Chairman.
Okay, all right, well, on the advice of counsel, Jacobson, we'll reschedule. Okay, so we'll move on to the next docket. A 14423, 1168 East 58th Street. And that one has been withdrawn. So move on to the next docket. A 14523, 5816 Gilbert Court.
Application and fees are in order. Notice of violation is no permit issued June 15th of 2023. Appeal was received June 30th of 2023, requesting for 100% release of reliability of the notice of violation. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson, Law. With the cited contractor and or his or her representative, please state your name for the record.
My name is Jolene. I'm the office manager for Gillichtig LLC, doing business as Gill Home Improvement.
Okay, and who else is supposed to be on? Is there someone else supposed to be on?
It's just the contractor who filed, Mr. Chairman.
Okay, are they on or is it?
That is the young lady who just spoke.
Oh, okay, Ms. Jolene. Okay, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and let us know what your plans are.
We did file for a permit. This was our first time working in the city of Cleveland. We actually thought that it was, the process was approved and we began work. We didn't realize that it's a multi-tier process. And they requested a drawing. We submitted that and they wanted some revisions of the drawing. So we were working really hard to get exactly what they wanted. The porch was mostly finished at the time. By the time we realized what all was going on, the homeowner, Veronica Silva Brown, she actually told the city we are not allowed back on her property, threatened our employees. And so after she sent notice to Supervisor Connie Tatum, I believe her name is, that we were not allowed on there, we asked what we should do. She recommended voiding the permit, and that's why we did that.
Okay, Mr. Vanover.
All right, bear with me, Mr. Chairman. There's a lot to unpack there. So, Mr. Chairman, the crux of the violation notice is work without a permit. And as such, both the owner and the contractor were cited for work progressing without a permit. To the appellate's testimony, work had been completed and it was almost finished, and it was finished without a permit. The ordinance is clear that no owner shall, have work provided on their property without obtaining a permit, and no contractor shall contract and produce work without there being first a permit. So understanding the relationship has since deteriorated. There's still an expectation that this contractor gain a permit for the work they completed, and then have that work inspected accordingly. It now appears as if there is a separate permit has been issued by to rebuild and repair the front porch.
What's happening?
Mr. Chairman, I apologize.
You okay?
This is new. This is very new. I mean, at the end of the day, the expectation is that both contractors are responsible for getting the permit and doing the work they completed. And Mr. Chairman, to Ms. Davis, Ms. Silva Velasquez is not on the call or in the hearing.
Mr. Chairman, this went over. No, the owner is not present.
So we're dealing with the contractor who never got the permit, but completed the work, I believe. And so, in their estimation, so I guess but they're fired. Okay. So, and you're saying they need to get a permit and have it inspected, and they can do that, right?
Mr. Chairman, the expectation, and again, I apologize, just after thinking through this, the expectation would be that the contractor completes what is required to complete their permit that began in April 10th of 2023. Obtain that permit, reach out to the inspector to identify the work completed, have it inspected. Then this permit can be closed as non-compliant, and then whoever is taking responsibility for the balance of the job will follow up on their permit. But at the end of the day, based on testimony and based on the record, work was done prior to the permit being issued, contrary to law, and relieving this contractor of any responsibility for work that they completed because they've since been fired is not a course forward. They still have to be responsible for the work completed.
Right. And even though they're not allowed to get onto the property, they can still have an inspector go there and inspect it, right?
Well, Mr. Chairman, if our communication, because the owner, as is required under the Residential Code of Ohio, because the owner has been cited as well, the owner, we can, our expectation would be to compel the owner to allow the inspector and the contractor on site for the purpose of inspecting the work.
You can do that. Okay. Well, that's what we'll require, because they're the one that's here, and that's the one we have to deal with.
So, Mr. Chairman, we would ask that you deny the request to remove them from responsibility and uphold the notice of violation for no permit.
Okay, and that's just what we're gonna do. So we are denying the request
Through the
for your
discussion.
liability, and we are going to request that you need to
Mr. Chairman.
have the work inspected, get a permit, and complete it. And so hopefully with the city will help you through this.
Discussion.
Mr. Chairman,
But who's talking?
this is Dan Jacobson from the Law Department.
Okay.
Okay. For clarification for the record, Ms. Jocelyn Litching, excuse me.
Jolene.
Jolene, can you state for the record the name of the business entity that is registered as a contractor?
Gil Lichtig LLC, doing business as Gil Home Improvement.
Okay. I just wanted to clarify that for the record. Thank you.
Okay, very good. Okay, so we are requiring that the work, you get a permit and that the work be inspected. And denying your release of liability. Motion?
So moved.
Moved by Mr. Dank, second by Mr. Bradley.
Can I ask one question? Being that the homeowner has been extremely difficult with us, is there a way that they can have a letter sent that they have to allow us, access and the inspector access?
Well, according to Mr. Vanover, I think they do have authority to be able to make this happen. So I think the first thing is you just need to go get the permit.
Okay. And again, we did already apply before the work was started. It was a misunderstanding. I spoke with Connie Tatum, the supervisor there. She said, as long as you send in the exact detailed drawings within 30 days, it would never even gotten to this point. And so this is not how we work. We always file and get a permit approved first. It was just a misunderstanding because Cleveland's process is so much more detailed than most of the suburbs that we have worked in.
Okay. So
Mr. Bradley,
go ahead.
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay. Notice will be sent out by the next meeting. Okay. Thank you. All right. We'll go on to the next docket is A14623. 11021 Parkview Avenue.
Application and fees are in order. Notice of violation is exterior maintenance. Issued June 26th of 2023. Appeal was received July 18th of 2023. Requested for 6 months to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing. Dan Jacobson, Law. With the appellant or his or her attorney or representative, please state your name and your relationship to the property for the record.
Good afternoon, everyone. My name is Juan Jara. I'm the property owner.
Okay, Mr. Howard, you solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, go ahead and proceed.
So, we bought this property and according to my notes, September 2022. Ever since we bought the property, we encounter a lot of issues with the tenants that were left behind with the property. Unfortunately, the seller that sold us the property gave us some false information about the property being vacant. And so since day one, we dealt with unauthorized tenants on the property. We had to go through a very long eviction process with tenants. That took months, I believe over 6 months, just to get the last tenant out. After we were successful doing that through different situations, the property was vandalized time after time. We have break-ins. The last break-in, I believe, was about a month and a half ago, where they broke in. They stole some stuff we had inside, equipment material, and some tools. We have made some attempts to get this property up and running. Unfortunately, we're not based out of Cleveland, Ohio. I'm in California, and so we one of the things that we did do, we're successfully able to do is to get a electrical city permit. We had a city inspector go out there. He called out a couple things. We hired a city license approved electrician. Those issues were resolved, and so ever since then we've been going back and forth from California to here, try to get the situation under control and get it all fixed. Unfortunately, we're not there yet. There's some hardships on our end. Obviously, the fact that I'm in California. I do run a business in California. I'm not here. I have not been able to find reliable, trustworthy contractors. Unfortunately, people say they're going to show up, they're going to give me estimates, they're going to do this, they're going to do that. They just don't. That's been one of the hardest things to do out here. Obviously, the cost is another situation. We are committed to make sure this property satisfies not only the city but also the neighborhood requirements. We eventually would like to get it rehab and rent it to a Cleveland resident. However, we're just not there yet. So I'm asking for a 90-day extension to get this requirements fulfilled. I'm asking just 45 days to allow me to get the necessary permits to get that going, and hopefully before that we get all this whole situation under control.
Okay, Mr. Vanover.
So, Mr. Chairman, this is a state to begin with. This is not an unfortunate circumstance. It's a business decision to purchase property in Cleveland, Ohio, when you're located in California. Well, so that's not a hardship. That's a decision. That was a decision that was made, and so we from the City of Cleveland Building Department discount that as a defense entirely. There's title work done when properties transfer. That title work includes whether or not there's tenants and what their relationship is, how long their lease is. So that's all due diligence work that is required. Part of the due diligence work when one decides to be a property investor in a municipality on the other side of the country, there's an expectation that there are already safeguards in place where one has contractors, they have a contractor pool, they have a pool of persons that they can depend on to do this. So we would ask that you deny any more time, that you remand it back to the Department of Building and Housing with the expectation that this corporate investor maintains a presence in the region so they can properly manage their assets, they can properly be good neighbors to the community and take care of their property as is required, as would be required in their home cities. So we ask that you deny any more time, remand it back to the department.
I respect your point of view. However, the main intention here, and one of the reasons why I decided to buy this property, was to make a old, abandoned, rundown property and make it look better for the community, for the neighborhood. All I'm asking is, this is the first time I've dealt with something like this. All I'm asking is to give some more time to make it right. And I don't think it's nothing out of shape to ask for some more time to make a property in the neighborhood, in the city of Cleveland, for a resident, make it look right, and that's all I'm asking. I don't think I'm asking for too much for this to be denied.
This is outside violation exterior maintenance, is that correct?
Yes, correct.
That's what you're looking at. And so we give you more time. We expect you to do it and get it done and without any delays. And so we'll give you 45 days to pull your permits. That would be January 20th, 2024 and March 5th, 2024, 90 days to abate the violations. And hopefully I won't have egg on my face. You'll get this done. Okay?
Thank you. Appreciate you.
Motion. Okay, moved by Mr. Dank. Oh, second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, you'll get a notice by the time our next meeting comes, I guess. All right, thank you.
Thank you, everyone.
Okay, next docket is A 23323, 12310 Irwin Avenue.
Application and fees are in order. Notice of violation is no permit and rental registration. Issued on August 22nd of 2023. Appeal was received September 19th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. Will the appellant or his or her attorney or representative please state your name and relationship to the property?
Hey, good afternoon. My name is Diram Sinarine. I'm one of the owners of the LLC.
Can Mr. C. Narine solemnly swear to tell the truth, the whole truth, so help you God?
Yes, sir, 100%.
Okay, go ahead and let us know what your plans are.
Okay, I already went to City Hall and I got the rental permit. I currently actually live at the house, but they told me that I have to pull a rental permit because I have a roommate. So technically, I'm still renting to somebody, so I needed to get a rental property. But when I bought this property, it was a boarded up house. It was completely in shambles. Me and my dad went in there and we renovated it because I was living with my parents until I moved in to the property. And then I came home one day and I saw the notices on the door. I talked to the inspector about the property and they told me that the short picket fences were fine. And the tall fences on the right side of the house, which is opposite of the street, were fine. But she told me that the fences on the back of the house were too tall. But the reasoning behind that, for me putting the 6-foot fence on the side, the back of the house, was because I live in front of a park. There's been criminal activity and gang activity there. Someone died there a couple years ago, and there's constant shootings around the area, and it's not the best area to live in. So I did that for my own protection, and I wanted to pull a permit, but I didn't pull a permit because I figured that maybe it's gonna get rejected. So I was planning to take and I needed to get a licensed contractor to pull a permit. So I was planning to actually take the house out of my business and go and try to pull it myself and see if you guys could have some leniency with the height of the fence in the back, because it's for my own safety,
Okay, how much time are you looking at here? You got it's a notice of rental registration and permit.
Yeah, I already went and did the rental registration. But as far as the fencing permit, I live in Cleveland. I live at the house, so I can go and get that permit pulled. But I don't know if it's gonna get approved because of the height of the fence. But I would really appreciate it if it could get approved, because
Yes,
Mr.
well,
Chairman,
hold on.
the board doesn't have the authority to approve or deny the height of the fence. We would ask that you uphold the notices as issued. There's a permit required, there's a review process. It is not proper, as much as I empathize with the appellant. You don't not pull a permit because you think you're gonna be told no. So this is a clear case of begging forgiveness instead of asking for permission. All of the fencing in place needs to be permitted, including the one in the front, which may or may not be compliant. It is not the inspector's, the inspector can grant assistance, but they do not do plan approvals. Rental registration is completed, that violation notice is closed. And it's as a corporately owned property, which this is owned by an LLC, you will need to have a registered contractor pull the permit, and you do not get the owner occupant exemption for a rental property if it's corporately owned.
Yeah, I went and tried to pull the property, I actually did go and try to pull the permit myself, but they told me that I did need a licensed contractor, so I was gonna just take the house out of my LLC because I'm technically living there, so I was just gonna take it out of the business and then go pull the permit myself. So that's what I was planning to do.
Mr. Chairman, those are legal decisions that the applicant can make on his own. I can't provide. But we ask that you uphold the notice that the requirement for a permit be upheld and go through the process. And if the design is denied, then there is a separate appeal process for that.
Okay.
Okay, so a motion is to uphold the violation notice and require the permit to be obtained. And that's it.
So is it?
Hold on. Motion? Okay, motion by Mr. Bradley.
Second.
Second by Mr. Dink.
Mr. Bradley? Mr. Dink?
Yes.
Mr. Gallagher?
Yes, notice will be sent out by the next meeting. Okay, thank you. Mr. Bradley, can you hear me?
Yeah, I hear you.
You can hear me. Okay. All right. You can't have any other conversation going on because it's bleeding over into the meeting. Okay. You're going to have to mute your phone in between. If that's you, because I think you're bleeding over into the meeting and I can't contact you any other way. So I got to tell you. Okay.
Quick question. You said there will be a notice sent out. Is that a notice to go pull the permit, or?
No, you can do that right away. That's just that you will receive this notification is basically what I'm telling you. But you can go down as soon as possible and take care of business.
Okay, and do I have to pay a fine because I didn't fix this in time?
No, the board has just said that you just need to get the permit. That's all we've said.
Okay, thank you so much. You guys have a great day.
All right, you too. Thank you.
All right, thank you.
Okay, next docket is 823423. 2764 East 127th Street.
Application and fees are in order. Notice of violation is condemnation of the garage and condemnation of the main structure. Issued on August 15th of 2023. Appeal received September 13th, 2023. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson, Law. With the appellants or his or her attorney or representative, please state your name for the record.
I didn't have an attorney for this.
Oh, who is this speaking?
Bonnie Smith.
Bonnie, are you involved in this property 8223423?
Yes, 2764 East 127th Street.
Yes.
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 Okay. All right. So solemnly swear to tell the truth, the whole truth, so help you God?
Yes.
Are you the only one giving testimony?
Yes.
Okay, very good. Then let us know what your plans are.
I was looking to have 180 days to get my contractor and permit into Cleveland. I currently live in the state of Nevada. My brother currently lives in Arizona. So we are not there. We had took steps to lock up the property. We had no idea that it had been re-broken into until I got an email stating that they wanted to do an inspection due to people coming in and out of the property. I had paid to have the whole yard and everything cleaned up, and we were going to work on it over the summer. And I got this email showing all the damage that has been done to the inside of my grandmother's house. Before my brother left Ohio, he was helping out a small family and they completely tore up the whole upstairs. And that's where our problem started. 2 cars were stolen out of the garage there. The washing machine was stolen out. The dryer was taken and brought back in. The deep freezer is missing from downstairs, and basically they went through the house trying to pull out the pipes because the pipes were copper. So all of the, as you can see in the pictures, how they ripped out the sink, they just demolished. This was like vengeful. Like I don't, yeah, it's really bad. And I don't see the full basement pictures on there, but they totally destroyed the basement as well. I do have someone who is willing to clear out everything from the house. They know how to do the permits and everything, but they are currently in Texas, but they can work in the state of Ohio as that is where they are from as well. And I can trust them to do what they say they're going to do, but we just have to all be able to get there. So even if I'm not able to be there for the full time that they're doing the work, I can trust that they'll get it done.
Okay, so your ask was 180 days to do what?
To get the permits and get started on clearing out the house and securing it with the metal board, the boarding it up with the metal closures until we can get the actual work started to make the repairs. But right now, we just really got to get everything out of there and just, you know.
Okay, I was looking for what you're looking to do and when. So let me get over to Mr. Vanover.
So, Mr. Chairman, we object to any plan that doesn't involve permits within 30 days and a time certain for the complete renovation of this home. Again, it is difficult, if not impossible, to manage real estate from across the country. And unless there's an expectation that one of the owners of this property is going to move back local, or that they are going to appoint a responsible party that is local to maintain this. This is a plan for someday. And we would ask that you deny any more time. You remand it back to the Department of Building and Housing for further action. The fact that it took the citizens of the city of Cleveland to pay inspectors to go to this property to even inform these owners of the condition of the property, I think is indicative of what's to come. So it's difficult to do. I don't discount that. And I don't see this plan doing anything, getting the neighbors and getting the community anything more than what they've got. So we ask that you deny more time and remand it back to the department.
A motion is in order to deny more time, remand the property to the Division of Building and Housing for any further action. Motion? Okay, moved by Mr. Bradley, second by Mr. Dank.
Mr. Bradley?
Yes.
Mr. Dink?
Yes.
Mr. Gallagher?
Yes.
Yes.
Okay, notice will be sent out by the next meeting. Thank you. Okay, next docket is housing docket. A23723 12618 Carrington Avenue. That has been withdrawn. So we'll move on to the next docket, A23823 3482 West 49th Street.
Mr. Chairman, this
Yes.
appellant had asked to be rescheduled till we have the fourth member present.
Okay, reschedule.
Next docket, 14323.
Yes,
This has been
Yes.
withdrawn.
thank you.
What is the address on that, please? 4881 Broadview?
That
I'm
is it.
sorry.
It's 481 Broadview Road. That is correct. All right, we'll move on to docket A23023 3138 East 98th Street.
Application and fees are in order. This is a notice of a permit extension request to continue work underneath permits B as in boy 210-21454. Present is Tom Vanover, Department of Building and Housing, Dan Jacobson, Law. Would the appellant or his or her attorney please state your name for the record?
Alphonse Hogan.
Okay, Mr. Hogan, solemnly swear to tell the truth, the whole truth, so help you God?
Yes.
Okay, go ahead and let us know what your plans are here.
My plan, sir, is I was looking to ask for 120 days so I could complete the interior and the exterior work. As the pictures that I submitted, I'm so close to having it completed, and I just need 120 days. Chairman.
Okay, let's check with Mr. Vanover.
Mr. Chairman, this is closure of a permit for, as invalid for failure to comply with the Residential Code of Ohio's requirement that work be maintained. And that is not abandoned for a period of 180 days. This permit was issued in June of 2021. And it is a correct condemnation violation notice. We ask that you deny any more time and remand it back to the department, and that you uphold the order given. There have been attempts going back to 2021, several in 2022, as well as 2023, where there have been tags left, there have been phone calls made with no response, short of any other evidence showing that work has actually been accomplished on this property. We have made multiple attempts to verify that work has been completed. The Ohio Administrative Code under the Residential Code of Ohio requires that the owner have the property open and available for inspection under the plan approval, and that they call us to communicate that the work has been completed and is ready for inspection. In this case, the owner has done neither. He has not made it available for inspection when we've made our attempts, and he has not called for inspection. There's no evidence that anything has happened. This does not prohibit the owner from pulling permits, new permits to conduct work, or, basically to do what he wants to do. However, we ask that you do not open allow more time under this permit as the plan approval is valid.
Excuse me, Chairman.
What's that?
I would like to speak.
Oh, go
when
ahead, Mr. Hogan.
I have reached out to the department to try to schedule an inspection because due to the fact when I purchased the home, it was already work done. The work that I've submitted pictures showing that I've done work on the property. As I state, I just need the 120 days. The work has been done. I have went down there to the department to speak and to get in contact with the inspector. And due to COVID, it has caused a lot of infractions. At the same time, I still show that I have done work on the property.
Okay, this does not, as Mr. Vanover has stated, this does not in any way stop you from, getting it re-permitted and finishing the work. But I think because this has been held for so long, I absolutely agree with them that we uphold the violation, and motion is in order to deny more time and remand the property division of building and housing for any further action. Motion?
So what does
Moved
that
by
mean?
Mr. Bradley,
Second.
second by Mr. Dink.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes, notice is going to be sent out within 2 weeks. If you got any questions about that, you can, about the next move, like I had just mentioned to you, that, you're going to need to re-permit it, and you can finish the work. You can, if it's almost done or whatever stage it's in, you can. This does not stop you from proceeding.
So I have to buy the permits over.
Yes, you're going to have to redo them again because they're way beyond. That's yeah, exactly. Okay.
All right, thank you.
Thank you. We have another permit extension, docket A-232-23, 2216 West 83rd Street.
Application and fees are in order. Notice of violation. This is a request for a permit extension underneath permits B 220-28507. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law. With the owner or his or her attorney or representative, please state your name for the record. Mr. Chairman, I do not see the executor, Nicole Stevenson, in the participation panel.
Okay, Mr. Vanover, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Mr. Jacobson.
Through the chairman to Ms. Davis, did notice of today's hearing get returned to the board's file for any reason?
To the chair, to Mr. Jacobson, no.
Through the chairman to Ms. Davis, have you received any form of communication, an email, voice message, or anything physically delivered to you on behalf of this appellant and or docket?
To the chair, to Mr. Jacobson, no.
To the chairman, the due process requirement of notice have been given to this appellant. The board can proceed with its hearing and ruling today.
Thank you, Mr. Jacobson. Okay, Mr. Vanover.
Mr. Chairman to Ms. Davis, you said that you have not heard from the executor. This appeal was filed by an executor to an estate?
Yeah, she had submitted paperwork, had emails from her and her attorney.
So the
uncle is the one who was the owner of the permits. So for us to accept the appeal, she had to prove to the board that she could file on the behalf. So it was going through probates. The attorney submitted to us the information that they did file in probate for her to become the executor over his estate to take care of her business, to take care of her deceased uncle's business. The attorney as well as her were emailed about today's hearing. And neither one of them responded or said that they were not going to be present today.
Okay. Mr. Chairman, this permit was closed as invalid as the plan approval became invalid for inactivity on the work under the Residential Code of Ohio. And we ask that you uphold that order or that communication that it is invalid. Furthermore, the permit for this property was pulled as a homeowner's permit. And to be reminded, the City of Cleveland Codified Ordinances requires that every property that has work done on it requires a permit. Furthermore, it requires that every time work is being done, that work be done by a registered contractor with the Department of Building and Housing. So every structure, all permitted, all regulated work must be complied with by a contractor. However, that rule has an exception for property owners that will personally, and the codified ordinance says personally, complete the work on their own. There is an exemption from contractor registration. I will say that if Mr. Rashid, Raymond Rashid, is deceased, he will not be personally performing the work, and therefore the homeowner's permit as issued is also invalid.
Thank you.
Okay. So
we ask that you deny the request and remand it to the department.
Yes, we'll do that. We'll deny the request, uphold that it is ended, and remand it back to the property of the Division of Building and Housing for any further action. Motion? Moved by Mr. Bradley.
Second.
Second by Mr. Dink.
Mr. Bradley? Yes. Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Okay, they'll receive notice by the next meeting. Okay, so we're going to move on to approval of resolutions.
That is correct.
Okay, now the 156, 57, and 58, what, we leave them out?
Yes.
Okay, we leave them off. All right, so A 114, 23, 118, 119, 120, 122, 124, 126, 127, 153, 154, 155, 159, 161, 162, 165, and 272, all 23 date. Motion. Moved by Mr. Bradley, second by Mr. Dink.
Mr. Bradley? Yes. Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Approval of minutes, November 8th, 2023. Are there any additions or corrections?
No.
Motion?
Motion for approval.
Okay, all right. Moved by Mr. Dink, second by Mr. Bradley.
Mr. Bradley? Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Okay, I think it's, yeah, I believe that we have got all the cases done here. And is there anything else to come before us?
No.
Okay. We're gonna lose the room here in a minute anyways, right?
That is correct.
Okay, all right, so the meeting is over.
All right,
That's it. We
next
are
year.
adjourned. Okay,
Bye.
sounds good. Thank you.
Thanks.